Okay, antitrust. This is a big one. And antitrust laws in the US are designed to promote competition and prevent monopolies or unfair business practices that harm consumers and restrict market freedom. So these laws ensure that businesses compete fairly, leading to better products, innovation, and fair practices. Lots of slides here, and so I have a ton of examples that hopefully will help this material to sink in a little bit. So some major pieces of antitrust legislation, probably most significant was the Sherman Antitrust Act of 1890, which was the first major antitrust law in the United States that prohibited monopolistic practices and any agreements or conspiracies that restrain trade. So probably the most prime example was Standard Oil, which was broken up into many smaller companies because of monopolistic practices. Chevron and Mobil, I believe those are the only ones on the West Coast, are descendants of Standard Oil. Clayton Antitrust Act of 1914 strengthened the Sherman Act by addressing key practices that were not covered in the original law, such as price discrimination, exclusive dealings, and mergers that substantially reduce competition. And the Clayton Act prohibited one company from buying stock in a competitor in order to avoid monopolization. So it strengthened antitrust actions against unfair corporate mergers and acquisitions. The FTC Act, or Federal Trade Commission Act, created the FTC to investigate and enforce antitrust laws. So the FTC was granted the ability to take action against companies that engage in false advertising or deceptive pricing and other unfair methods of competition. Robertson-Patman Act of 1936 focused on price discrimination that harms competition, particularly in wholesale trade, so prevents large retailers from receiving unfair discounts that would drive smaller competitors out of business. So it helps to create an even playing field among competitors in key areas of commerce. Antitrust in the United States is enforced two places: by the DOJ, who prosecutes antitrust violations and reviews mergers for potential anti-competitive effects, and the FTC, which enforces antitrust laws by investigating businesses and issuing penalties for anti-competitive practices. Antitrust is also one of those areas that is civil and criminal in nature in terms of the enforcement and regulation of the law. So within the United States, some key antitrust practices, and I'm going to talk about monopolization in detail a little bit later in the lecture, but monopolization, price fixing, mergers and acquisitions, and exclusive dealings, prohibiting businesses from using contracts to force customers or suppliers or to work only with them to the exclusion of other competitors. And so I'm going to talk about these a little bit more in detail as we move through the next few slides. In terms of enforcement, the Department of Justice has the Antitrust Division, which is responsible for civil enforcement and criminal enforcement of antitrust laws. They investigate violations. They, as I said, review mergers. And so they can bring lawsuits against companies engaging in legal agreements like price. FTC reviews mergers to make sure that they don't create monopolies and investigates unfair competition, such as exclusive dealing or predatory pricing. And so the FTC has the ability to block a merger if it believes that the merger is going to significantly reduce competition in it. Again, civil enforcement, both the DOJ and the FTC have civil enforcement through injunctions that can stop anti-competitive behavior, or they can require the divestiture of company assets to restore market competition. Basically meaning like if two airlines want to merge, and so Alaska Airlines and Southwest Airlines want to merge. And so what the FTC can do is say, okay, well, because your merger is going to create an airline that's too big and has too much market control over certain areas of the country, you're going to have to sell some routes in order for us to allow the merger to take place. So they might sell some routes from that go to Hawaii, or routes that go to I don't know, New York. And so that would be an example of a divestiture. They also, in terms of the merger review, companies have to notify the FTC and the DOJ of large mergers. The agencies then investigate the potential impact on competition before approving, modifying, or blocking the merger. Private parties, such as competitors or consumers, can bring civil lawsuits if they are harmed by antitrust violations. Typically, plaintiffs can recover what are called treble damages. I think we talked about those. It's triple the amount of the actual harm. So suing for $100,000 gets you $300,000 with treble damages. So price fixing is when competitors get together and agree to set prices rather than letting market prices determine them on their own. Price fixing is illegal, and the DOJ prosecutes price fixing as a criminal offense. So an example of that would be like if several airlines got together and agreed to charge the same fees for baggage without allowing for natural competition. You hear about price fixing in lots of markets. Sometimes they're conspiracy theories, sometimes they are actionable, but you see prosecutions about price fixing come out a few times a year from the DOJ. Monopolization is when companies get together to dominate a market through exclusionary or predatory practices. Currently, Google is accused of employing monopolistic practices in keeping other companies out of the search space. And when you think about it, Google has a pretty tight monopoly on search. At least I can't think of a search engine that other people use. So a tech giant using its market dominance to block competitors from entering the market could be forced to divest part of its businesses. Mergers and acquisitions. Mergers, two companies that come together to form one company. Several years ago, United Airlines and Continental Airlines merged to be United Continental. So mergers that significantly reduce competition can be blocked by the DOJ or the FTC. Sprint and T-Mobile, I think, wanted to merge, and the FTC said, no, that's not possible. I'm pretty sure that they knocked that one's not happening because of that, but I could be wrong. They might have just required a divestiture. Bid rigging occurs when competitors agree to control the bidding process, typically in government contracts or auctions. So construction companies that are conspiring to fix bids on public projects would be subject to a DOJ investigation. This is criminal, and it would be prosecuted by the DOJ. Exclusive dealings are agreements where suppliers force buyers to only purchase from them, restricting the competition. So a dominant manufacturer requiring retailers to exclusively sell their products to the exclusion of competitors could face antitrust penalties. So what are the penalties? Fines. For criminal violations, companies can face significant fines. Individuals could be imprisoned. You don't imprison companies, though. Companies face fines, or in extreme examples, they might be forced to disband, or they might lose their corporate protections. Injunctions for civil violations. Courts can issue orders or injunctions to stop anti-competitive behavior, which would be like stopping a merger. Divestiture in merger cases. Companies might be required to sell off parts of their business in order to maintain competition. And then treble damages, we talked about that. That's triple the actual damages in a lawsuit. So let's talk about restraints of trades. There's two types of restraint of trades. There's horizontal restraint of trade and vertical restraint of trade. Horizontal restraints of trades are agreements that are made between competitors operating at the same level of the market that restrict competition. So two competitors, Coke and Pepsi. These practices are illegal under U.S. antitrust laws because they undermine market competition. They lead to higher prices, reduced output, and less innovation. So how do horizontal restraints of trades work? Many times you might have price fixing and exchanging price information. So two competitors agree to set or maintain prices at a certain level rather than allowing market prices to determine pricing. That would be a horizontal restraint of trade. Horizontal restraints of trade are illegal under antitrust laws. You don't have to prove harm to the competition. It is automatically illegal whenever two competitors get together and set their prices. Market division or market allocation, which is allocating territories. So competitors who agree among themselves to divide up markets geographically or by customer type, eliminating competition, is an example of market division. Two restaurant chains that are competing agree that only one will operate in the western region and the other will operate in the eastern region, preventing competition between them, is an example of market division. Again, also per se illegal, meaning that you don't have to show that it restricts competition, or you don't have to show that it's doing damage, you just have to show that it's happening. Bid rigging, competitors agree in advance who will submit the winning bid in a bidding process. So I'm going to submit this winning bid, and then because of that, you submit that winning bid. And so we each get a winning bid. That is also per se illegal because it undermines competitive bidding and leads to inflated prices for goods and services. Group boycotts, an agreement between competitors to refuse to deal with a particular supplier, customer, or another customer in order to restrict competition or pressure others. So a competing grocery store chains agree not to buy products from a specific supplier unless the supplier raises price for all suppliers or all other retailers, is what would be a group boycott. Also illegal because they have the intent to harm competition. Vertical restraints of trade are agreements between companies at different levels of the supply chain, so a manufacturer and a wholesaler, or a wholesaler and a retailer. These restraints of trade either restrict or promote competition, and their legality depends on the impact on the market. Vertical restraint of trade is also analyzed under what's called the rule of reason, which considers whether they harm or benefit competition. So, vertical restraints of trade. Resale price maintenance, or RPM, which is an agreement between a manufacturer and a retailer that sets the minimum or maximum resale price for a product. So manufacturer requiring that a retailer not sell a product below a certain price to maintain brand value. You see this with actually a lot of luxury goods where Louis Vuitton, for example, will not let anyone sell their products below a specific price. It's not necessarily illegal if it does not harm competition, and we have lots of luxury brands out there. So under the rule of reason, it's determined that that is a legal restraint of trade practice. Exclusive dealing arrangements or agreements. Supplier requires a retailer to only purchase and sell the supplier's products, excluding all competitors from the market. So a soft drink company requiring fast food chain to exclusively sell its brand and not competitors' beverages. Again, this falls under rule of reason, and you see in many fast food chains, they either sell Coke products or Pepsi products. Typically, this is only illegal if it impacts competition among other soft drink companies. A tying arrangement is a seller requiring a buyer to purchase one product as the condition for buying another product. And so an example would be a computer manufacturer requiring customers to buy its proprietary software as a condition of purchasing its computers. Apple used to do this a lot. Prior to the App Store, you had to go through everything Apple did was proprietary. Now, by virtue of the creation of apps and the App Store, just about anyone now can create an app. So you can have your software on an Apple device, and it has created a competition for a plethora of millions of different types of apps. Vertical market division is an agreement where a supplier or manufacturer limits where or to whom a distributor can sell products. So a car manufacturer assigning specific regions to different dealerships and then prohibiting them from selling in other regions. Sometimes called territorial protections. They're legal as long as there is an efficient distribution chain. If they restrict competition too severely, then they would be deemed to be illegal under the rule of reason. Price discrimination. Sellers are prohibited from offering different prices to competing buyers for goods of like quality and grade if the prices harm the competition. So for example, a supplier charging a large retailer less per unit than the same product for the same product compared to a smaller retailer, giving the larger retailer a competitive advantage. Price differences have to be justified by factors such as cost savings, changes in market conditions, or different quantities purchased. So if Walmart goes and buys a gazillion toilet Kleenexes, toilet papers, whatever, they can justify selling it at a lower cost because they're buying in bulk or purchasing at a lower cost. Secondary line injury is price discrimination that harms competition among buyers, i.e. customers of the seller. This occurs when one buyer receives a lower price than another, which puts it at a disadvantaged buyer, which puts the disadvantaged buyer at a competitive disadvantage. So a large chain receiving a discount from a supplier that a smaller retailer can't get would be an example of a secondary line injury. Defenses. Cost justification. Sellers can defend price differences if they can prove that a lower price refers actual cost savings in production, transportation, or sales. So for example, a manufacturer offers a large discount to a large buyer because the cost of shipping large quantities is lower than for smaller orders. Buying in bulk, shipping in bulk, cheaper, so we can charge less. Meeting competition defense. Sellers can justify price discrimination if the lower price was offered to meet but not beat a competitor's price. So if you're meeting a competitor's price, not beating it, that is, and you can demonstrate that the lower price was necessary to stay competitive in the market, totally legal. Functional discounts. Price differences may be legal if they reflect different functions or services provided by buyers. So a wholesaler receiving a discount for taking on additional marketing responsibilities, while the retailer does not receive the same discount, again, is a functional discount defense. Changing market conditions. Price changes that reflect a change in the market conditions, such as the perishability of goods, seasonal discounts, promotional pricing, are all allowed under the Robinson-Patman Act. So a seller reducing prices on seasonal items at the end of the season to clear inventory is an acceptable defense. Sherman Act of 1890 is the big piece of antitrust legislation. Section 2 focuses on monopolization, attempts to monopolize, and conspiracies to monopolize. It is aimed at preventing a single company from dominating a market, thereby harming competition. And so market power is the ability of a company to raise prices, reduce output, or control the terms of market participation without losing significant sales to competitors. Companies with too much market power can harm consumers by restricting competition, which leads to higher prices, reduced innovation, and fewer choices in the marketplace. Monopoly power occurs when a company has a dominant control over the market and can manipulate prices or exclude competitors. Two key components. First, possession of monopoly power in a relevant market. Like I said, the one that comes to mind is Google. And willful acquisition or maintenance of that power through anti-competitive conduct rather than superior products or innovation. Again, there's a lot of folks that say that Google forces people into and out of markets and forces people to do business with them. Google's an interesting company, but that's an aside. So the courts apply a two-part test to determine market monopolization. The first is the monopoly power in the market. Does the company control a significant share of the market, typically more than 70%? And did the firm engage in behavior intended to suppress competition, such as predatory pricing or exclusionary practices, in order to get to that 70% or higher? A company doesn't need to have monopoly power in order to violate Section 2. An attempt to monopolize is enough as long as there is a probability of success. So the key elements of that are intent. Did the company intend to achieve a monopoly? Have they been engaging in anti-competitive behavior conducted in order to eliminate competition? And is there a realistic chance that the company could succeed in monopolizing the market? So an example of that would be a company lowering its prices drastically in an attempt to drive competitors out of business with the intent to raise prices once it achieves monopoly power. The Chinese government was accused of doing this with solar panels not too long ago, that they were selling solar panels, flooding markets with solar panels and selling them cheaply in order to drive out the competition, in hopes that once the competition was gone, they could drive prices up again. So penalties and remedies under Section 2, injunctions, we talked about that, fines and damages, and divestitures, all typical fines and remedies used under Section 2 by the DOJ. Clayton Act was designed to promote fair competition and prevent anti-competitive practices. Section 7 of the Clayton Act specifically addresses mergers and acquisitions that may substantially lessen competition or tend to create a monopoly in any line of commerce. Section 7 is aimed at preventing companies from gaining excessive market power through mergers and acquisitions, which could harm consumers and competitors. Section 7 involves horizontal mergers, vertical mergers, and conglomerate mergers. Conglomerate mergers are mergers of companies that have completely unrelated business activities. So an airline buying a car manufacturer. So under Section 7, the Hart-Scott-Rodino Act requires companies planning significant mergers to notify the FTC and the DOJ before completing the transaction. This gives regulators the opportunity to review the merger, to assess the potential anti-competitive impacts. So what are the remedies for anti-competitive mergers? The FTC or DOJ can sue to block the merger if they determine it violates Section 7 by substantially lessening competition. Or they can order divestitures, which we talked about that, selling certain assets to restore competition to the marketplace. Or there also might be behavioral remedies, such as not engaging in specific practices that would eliminate competition. So a vertical merger might proceed under the condition that the merged firm cannot limit access to key suppliers for other competitors. So we talked about enforcement. Section 7 is enforced by the FTC, who reviews and challenges mergers primarily in consumer-focused industries such as retail and healthcare. The DOJ focuses on mergers in industries that tend to be regulated, like telecommunications, technology, and defense. And if either agency finds that a merger violates Section 7, they can file a lawsuit to stop or unwind the merger. Also, private lawsuits can be filed by competitors, suppliers, or customers that are harmed by a merger, or they can seek damages to stop the merger. Whew, that was a lot. Antitrust. Lots of jargony stuff here. What's really important is to have a general understanding of what antitrust is and how antitrust laws work in order to protect consumers.